A relinquishment deed is a legally binding document in which a legal heir gives up his rights under inherited parental property for another heir likely to be mother, children, or siblings. This process of distributing property from one co-owner to another co-owner with or without any consideration is formally known as relinquishment of property. Relinquishment of right is regarded as the surrender of one's own ownership rights and claims in order to transfer property to some other owner. The Transfer of Property Act has not defined this, but it is a recognized practice. Under this, the consideration, if made, can be in the form of money, exchange of estate, or any other arrangement between the family members, or can be without any consideration in some cases. 5 important steps to relinquish a property are: first, the property can only be relinquished by a legal heir, and in a situation where there are more than one legal heir, then either of them can initiate the relinquishment. Second, the relinquishment can only be done in favor of another co-owner or legal heir of the property and not anyone else. Third, it should be pointed out that in case the relinquishment is made to anyone other than the co-owner, then it will be deemed as a gift and all the regulations in accordance with the gift deed will come into effect. Fourth, the relinquishment of property can only be done via writing, which is known as a relinquishment deed. It should be duly signed by the co-owners and attested by a minimum of 2 witnesses. 5. The relinquishment deed should be registered in the office of the Sub Registrar within whose jurisdiction the property is located. The registration of the relinquishment deed is a legal instrument which permits the heir with the right to create or transfer the immovable property. Hence, it is a mandatory provision to give the co-owners the legal validity. There are 6 steps involved in the registration of a relinquishment deed. These are: first, prepare the final draft of the relinquishment deed through a lawyer. The deed must be prepared on a stamped paper of rupees 100 with every detail about the estate. This deed should also be signed by all the co-owners and a minimum of 2 witnesses. Second, once the deed is made, then it should be submitted before the sub registrar office within the jurisdiction of the location of the property in question. Third, the registration fees of rupees 100 to 250 should be paid. This registration fee varies from state to state. Fourth, all the parties and the witnesses should be present at the office. They should also carry their respective identity proofs, original and a photocopy, and passport size photos. Fifth, if the office is convinced of the authenticity of the deed, then it will be registered within a week. The competent parties can then visit the office and collect the papers. And sixth, in case the relinquisher is handicapped and is unable to visit the sub registrar's office, then under section 31 of the Registration Act of 1908 allows the registering officer to visit the residence of that person. Thank you.